The desk.
In the desk?
Yeah.
Oh.
It's a good trick if you have
That
a
was,
drink, right?
yeah. Think of that. Would you like a glass of
Oh,
water?
that makes it good.
Okay, so it is 5 o'clock and I will call the meeting to order. Could we have roll call, please?
Mayor Smith,
Here.
Mayor Pro Tem Valentine,
Present.
Trustee Stelter,
Here.
Trustee Schwartz,
Present.
Trustee Brunner, Trustee Check.
Here.
We have a quorum.
Okay, could I have a motion to approve the agenda?
I motion to approve the agenda.
Okay,
Second.
all right, we have a motion second and all in favor?
Aye.
Excellent. So we are now starting our town interviews and we have with us John Maloney. Maloney, who drove over from Glenwood.
That's right.
So you just heard who we were, so you probably don't need necessarily an introduction from us. Are you comfortable that you know?
Okay, yeah,
We
the name
got our
tag.
signs, very good. So what we have a series of questions and we will each take a turn asking you a question, but I'm gonna go ahead and open it up with just to ask you, what made you decide to apply for the position in Payne?
Sure. Well, I've been a litigator for 25 years. And I left Washington DC for Colorado in 2013. Was running my own practice and occasionally had municipal law issues. But then in 2018 went to work for the city of Florida. And there we had a 10-attorney city attorney's office, and I was deputy, which was second in charge there. And we had just had a slew of issues coming through. And I found that type of work to be much more satisfying, working in the public good than just representing private interests, which I had done much of my career. I moved to Glenwood Springs in 2021 because I had a kid and I'm raising him here or there on the other side of the pass. And went to work for a private firm in Glenwood Springs, and that sort of ended at the end of January. And I've opened a mediation practice. And so I'm running that right now, and I'm looking to pick up clients on my own without a firm, not looking to go back to a firm. I was in solo practice for 11 years in the middle of my career, and that's sort of where I find myself again, looking for good municipal clients.
Great, thanks. So we'll start if we'll just do like we did last time, Bill, if you'll take the first question, we'll just go around the room. Thank you.
Okay. So please describe your experience addressing issues regarding water rights, water and sewer infrastructure, and water availability for residential users and other pertinent water issues affecting the western slope.
As mentioned, I'm a litigator. I'm not a water lawyer, but I've been water lawyer adjacent for the past 2.5 years, working with the Glenwood Springs water law firm. They do water law. If they need to run into court and fight about it, I was the guy who did that. Some interesting western slope water issues that I learned about doing that was the watershed sort of statute, which allows municipalities to claim a radius where they can exercise jurisdiction outside of their municipality in order to protect their watershed. I, of course, learned that issue when I was dealing with whether or not it was being done correctly, trying to have a private landowner do something on his property. So that's a sort of a western slope push and pull with municipalities that I learned. I've driven with ditch company board members looking at entry to inspect and operate and maintain and repair ditches where a dispute has come up, and strangely, people are closing their gates more now, where that's not what they were used to having, and then they have to decide where that right of access should be.
When you say gates, you mean a gate, to a road gate, not their
Right,
irrigation gate.
right, a road gate, a literal road gate. People fight over water. People are more contentious these days, I hear, than they were 25 years ago. And that's one of the issues that I've observed out here, which is, you have a right to your water, but it's not necessarily clear where that excess is, where a private property owner is in enforcing those private rights. I've written memos about the interface between a private water district and a municipality where one, again, those jurisdictions can overlap. And that creates issues, and I've had the opportunity to look into that over the past 2.5 years. And also being water adjacent on the Front Range, I was involved with at least the portion of the appeal and nearby Thornton's 70-mile water line, where they dried up a bunch of farms north of Thornton, but couldn't get their water for a period of many years. And so I saw what it took to go through the eminent domain, dealing with the counties, getting the rights to put a pipeline of 70 miles, even though they had their rights to the water. So that's a long way of saying, I'm not a water lawyer. If you need someone to appropriate rights or that sort of thing, there are specialized firms that do that. But I have been adjacent enough as a litigator that I've run into court for water issues a lot over the past 2.5 years.
So that I'm supposed to read this follow-up question too. What did you do to get all the information? What was the solution?
Yeah, that sounds like it's more like an appropriation question, but yeah, it's the cases that I described are normal litigation. I interviewed the relevant people and went out on site, because it always matters to see what the geography looks like when you're dealing with land rights and water rights and that sort of thing.
Great. Okay, so please tell us about your most contentious negotiation and how was it resolved? In addition, please describe your experience with alternative dispute resolution.
Okay. I have had a recent contentious negotiation that involved the town and a business that had been in business for more than 50 years, doing things a certain way, had been sold to new owners 10 years ago, had a lease because the business was run on town property, and the town officials were getting a lot of pressure to have the business leave. And so it wasn't a matter of not payment of rent, but there were sort of best practices that were involved in the requirement for the business. And that was very vague. And so it wasn't clear what was going to happen in court. But the town sued and we negotiated. We had a professional mediator. And sort of with that, did not resolve it. We went through all of the issues of how difficult it is for a family business to shut down, for all of the municipal officials to deal with hearing the public's opinion on something that's a hot button issue, and sort of found out through mediation what the sides wouldn't do. But we didn't stop talking, and then showed up again later just with the town manager and got a little closer again. And then finally, I made an appeal not to the business owner's rights, not about the business owner's rights, but about what the community would be losing with losing this business that had been there for 50 years, and got some more time. And it eventually settled, with the settlement being to leave, but not as fast as you wanted to, give them time to sort of shut things down and do things right on the way out. So it was contentious, but by bringing in the community interests, we were able to get it done. And my experience with ADR, and I've worked for a financial firm that had arbitration clauses in all their contracts. So I've done a bunch of arbitrations, and that's a lot faster than court. That's one benefit to that type of ADR. And mediation is sort of the other thing that falls under ADR. I took mediation training last summer. I've been acting as a mediator to attempt to resolve cases more recently. And I've done a bunch of mediations as an advocate throughout my career.
Thank you.
What piece to that one, Kathy?
Oh, yeah, thank you.
This is one.
What is your experience with prosecuting ordinance violations in municipal court?
I supervised the 2 municipal prosecutors in Thornton. I did not, and it was a full-time court. I know that, I think here it's 1 day a month. There it was 5 days a week, high volume of municipal cases. It was a lot like parenting though, don't steal that candy bar, stop driving so fast, don't punch those people, that type of case that came up. And, I only ended up in court if something unusual happened, right? If a case that was supposed to be an hour ended up going 3 hours, then I would have to go down and fill it in. But I was not prosecuting full time, but I dealt with any of the unusual issues that came up. Early in my career, I worked I was in a prosecutor's office interning and helped people over for trial and did that sort of prosecuting stuff. But it was the high volume of municipal stuff that I supervised recently that I think would be most helpful for a once a month court.
Explain your experience with developing wording describing the purpose of an executive session for the incorporation into a trust meeting agenda with respect to the Colorado Open Meetings Law. What is your approach when advising trustees on the pros and cons of entering into an executive session, which was not part of the agenda?
Okay, two separate things. The first one, I did represent as the attorney for a number of boards, and we had the same requirement to go into executive session. And so let's say, cite the statute 24-6-4024, B if it's attorney advice, F if it's personnel, and just make sure you cite the statute. And I've been watching the Colorado appellate courts require specificity of what you're going to talk about recently. And so it doesn't have to be a lot, but if you're going to have a conference with your attorney, you don't, in fact, waive attorney-client privilege, which is one of the arguments, if you say, we're going to talk about this issue. And so you should at least go that far. It's about a case, like the case number. If it's about person, say what you're talking about. And if you're using the personnel one, say who you're talking about. But not much more. I mean, they require something, but not much more. It's sort of basalt got hit 4 years ago. I can say how much to say and not too much. The pros and cons of going into executive session without noticing it. There's rarely a reason to do that. You can call a special meeting with 24 hours notice. And the pros of doing it are you can talk about something in executive session immediately. The con is if you didn't notice it within 24 hours, if you didn't give 24 hours notice of the meeting, the recording of the meeting could be made public and you could have to pay the attorney's fees of the person who required that to happen. That just happened in Glenwood Springs. They ended up paying $20,000 and releasing the recording of the meeting. So that's a con of doing it without notice. I have seen some entities that always include as a last item agenda item, possible meeting with attorney for anything that's an action item. And so that way you can at least get attorney advice, having noticed that you might need to ask your attorney something in real time, so you don't have to take that 24-hour break. So there are sort of ways to at least get attorney advice without noticing a special meeting.
That would be like an executive session immediately following a normal town council, for example.
Yeah.
Just to get the advice without the public present.
Right, and I've seen that on the agenda. I haven't seen it go through the appellate courts, right? But I've seen some entities do it that way. So they're preserving the right to talk to their attorney in executive session only for an item that's already been noticed.
But it's like it's a boilerplate on their agenda packet, on the agenda.
Yeah.
They just have it at the end of every agenda, just as a fail-safe. Interesting. Look, it's my turn. A sense of urgency can at times compromise thoughtful decision-making in a thorough process. Can you think of a few examples of when this happened and what was your role?
COVID was an interesting time to do regulations in a municipality. And we were every day, it was in many ways most interesting with marijuana because that was a business that the state was trying to keep running, and it was also something that they were trying to, that has its own, 300 pages worth of regulations. But then the state would pass other things. And a particular example was that it could be only be sold curbside. And so we passed regulations about sort of curbside sale of marijuana, but the existing regulation said it couldn't be sold outside the building. And so we were seeing decisions being made really fast where, this code is being altered because there's an emergency. People need to make decisions quickly, but it conflicts with this other code over here. And then we scramble and come up with a definition of a curb that is maybe not the curb by the road, but the curb by the parking lot near the window, so they can sell it out the window, still in the building. And things like that happen when you're making decisions, like happened all the time in COVID, without painstakingly going through and seeing where this part of the code conflicts with this part.
So as a thought, tell us about a time when you came across a situation or a decision that you didn't agree with. How did you handle that?
I was responsible for liquor licensing as well, and I had an officer who really came down hard on an establishment that had made a sale to a minor. And we had a sort of standard 7 days, 6 in the bags. And so the institution that did it had to take 1 day off. But this officer didn't just cite that, cited 5 other violations that were about the same thing. Looked at different places in the code and came up with the wording for that. And I asked him to change it. And so I didn't agree with what a police officer had done, what a detective had done. And he heard me, when I asked him to change it, what he heard was that I was asking him to change his factual findings. And so he didn't agree with that. And I didn't agree with treating this business apparently differently than other businesses. And so we ended up having to have a meeting with both of our bosses present, and we worked it out, where I was clear to him that I was not asking him to make any change to his factual findings, but to treat it more like something you would give to a prosecutor where here's a potential violation, here's a potential violation, here's a potential violation, and do it on 6 different documents, and then let me pick which ones to actually prosecute and exercise that discretion. And so we worked it out.
What's your experience with disruptive or contentious meetings, rules, procedure for board meetings or other meeting situations that require attorney involvement to help maintain order?
I'm on the Garfield County Library Board, I'm a board member, and I have been called, I've been told to go to hell. I've been called a Marxist to my face, about this far away in public comment, and I've seen from that side of the table what these disruptive meetings can look like. And the way we deal with it is simply enforce the rules evenly with all people. We have a timer, a 3-minute timer, and when that's over, the person's time is over. But as representatives of the public, we do need to hear what the public has to say. There are lines, right? There are threats of violence or some language that can go too far. But I have seen those disruptive meetings up in my face. We haven't had to get an attorney involved. Generally, it's the presiding officer, mayor, that takes care of running the meeting and enforcing the rules. I think that I could take a hint if you said, does our attorney think that we should go past 3 minutes for this one? And I would say, no, I don't think that we need to treat everybody equally. So this person should sit down just like anybody else in the position sit down. And I could do that interaction with the presiding officer, I think. But
Yeah, there seems to be sort of an organized group of, particularly with libraries, to censor books now when they get information from the side or something. But what advice can you give us about the inclusion of public input as it relates to the length of meetings and making wise decisions?
I mean, that's more of a personal question than a legal question. Personally, I think it's important. It's important to hear from the public. You don't want your meetings to go to midnight. And it's fair to have cutoffs as long as you're doing the cutoff based on a standard that you use every time, right? You can't decide that you don't like what someone's saying and cut it off. But if you say, we're gonna have public comment for 30 minutes every time, and then it's done, you can do it that way. And I think that's a good way to do it. It's important to hear from the public and.
Right. Well, yeah, I was thinking more of like monopolizing a meeting and having, somebody demanding more time.
Right. Yeah, and no, I think that you, in order to get business done, you need to be able to take a hard stand on preset limits, right? There are some entities that I'm aware of, government entities, few, that don't time at all. They will just go and go and go and go. And it's rough on board members. It's rough on other members of the public, right? And they also, I've seen back and forth. And I think that YouTube has inspired that back and forth. You know, people will show up in public meetings and try to bait board members. I also think that sometimes the public needs to hear what you're thinking in response to their comments. But my personal opinion, and something that we've implemented on the board that I'm on, is listen to public comments at the beginning and then have trustee responses at the end. And so you're not going back and forth with an individual in a public setting, but they can hear you, right? They know that you heard them if you do want to make a response, but not invite them back up to respond to your response. It's separated with some time and space.
Can you describe an example of a time where your legal opinion helped bring a positive outcome to the community?
I was more of an enforcer than an opinion maker, but I had to provide an opinion about how a lighted shopping center was or was not complying with code. And so we found, well, I mean, the code officer found like 80 violations, and I think we narrowed it down to 50 and pushed all of them. And eventually it improved the condition of the lighted shopping center in the middle of the community. And it was something that was, a legal opinion actually enforced that changed the community for good. We knew that the community was going to like it because they told us at meetings all the time that this was something that they wanted action on. And that was sort of, an opinion about the enforcement of every single section of the code that could be enforced there.
Now think of a time when your opinion was not well received. What was the result?
We implemented a judicial oversight committee where sort of recently some things have changed a lot in some criminal law over the past four or 5 years. And we've reviewed a well-liked judge who had been a municipal judge for 30 years. And there are changing standards for bail and for some jail time, for bond, how quickly you can get out. And it was not well received to say a well-liked judge who had been doing things the same way and had been working for 30 years. And so that was an instance where there was pushback from the town, from the municipal court, and ultimately some things got changed. And it's tough, but that's one of those things that's tough, where you're providing legal advice to someone that's been doing things the same way for a long time, but the law has been changing. And you just have to, I guess what I learned out about in that one though, is the way you deliver it matters, right? Just because the law has changed, you don't need to say, this has changed, this is how things are now. You can sort of ease in or approach the question together in a way to get buy-in better. And so I did learn a little bit about how presenting something can affect the outcome.
See, please think of a time when you had to redo a work product because it didn't meet standards. What was the context and outcome?
I tell you about a meeting that I filed and a judge called me and told me I should redo it. But only after I say, before I did things like that, I worked for some law firms that worked for engineering firms that fought with GM or Caterpillar versus Korematsu. And we double and triple check things. When we had spreadsheets, we would print them out and then check them by pencil too, and make sure everything's perfect. When I went into private practice on my own, I was taking a bunch of cases, and I took a case that was an accountant who sort of referred a contractor to a homeowner. They're both his clients. You know, it's like contractor meet homeowner, homeowner meet contractor. Maybe you can strike a deal and do some work with each other. It was a father of a friend, and he really was not happy about being in court. He didn't want to spend a bunch of money. And I wanted to get him out of this, but we had to take some depositions, get some interrogatories done, and we did that. And I got all of the answers that I needed, right? Which is, no, the homeowner didn't rely on him. Yes, the homeowner knew that he could go do his own due diligence on the contractor. Yes, you know, he could investigate and find out if other people were happy. And then I filed a motion for summary judgment, which is a motion that says, court, judge, please let the accountant go without having a trial and stop wasting the time and money of the accountant and the time of the court. But the way I did it was I basically turned my notes into an outline and didn't take a whole bunch of time. I referred to interrogatories as rod 1, rod 5. This is what it says. And it was shoddy's not even the way to describe it. It was a less complete filing than the court was looking for. And the judge called me up and said, you can't file like things like this in my court. It looks like an outline. But then ruled in my favor anyway, because we were right. And so that, again, was presentation matters. That was finding that line in that particular instance where, you know, the perfect is the enemy of the done, and that just needed to be done quickly and inexpensively, but I needed a little bit more.
Let's see, and then what methods do you use now to check for quality, especially when you have to meet tight deadlines?
The firm I was just with, I used a paralegal who had been there for 27 years. Now I'm on my own. I have talked to a paralegal who does contracting for someone that I did a trial against, who was very good, and I would get a second set of eyes on anything that I needed to file, or no, like ordinances too. I guess I didn't talk about that before, which is, you know, when you're changing ordinances, you need to get a second set of eyes on it. That goes in the code, that stays there, people rely on it. And so I do have a professional relationship with a paralegal who can be a second set of eyes. And frankly, I try to print things out because when I'm staring at my screen all day, it looks like I want it to look like. And then if I print it out, I can see where I'm missing a comma.
Okay, please describe how many municipalities you're personally representing at this time, and will you have any scheduling conflicts that would require others to serve in your place?
I am not currently serving any other municipalities. And so the good part of that is it would not lead to any scheduling conflicts. I've got second and fourth Tuesday free. I expect to be out of town on September 10th. But besides that, my evenings are free for meetings and I can schedule mediations around sort of the town schedule.
Madam Mayor, may I ask an amended version of this question about statutory town?
Sure.
Okay,
I mean, if you think it's pertinent
I do.
to change, okay.
Yes. Okay, so in your previous experience, how many of the towns that you worked with were statutory?
I have represented home rule towns.
Okay,
They're not statutory, but in my experience, and so, I mean, home rule is, there's a home rule charter, which is like the Constitution, and that's where you go in order to find out what controls on a number of issues. For a statutory town, it's in Title 31. I mean, that's sort of where the statutory town's constitution is. And I know that you go look there for the requirements for statutory towns. And so I suppose I've done some litigation against statutory towns, but have not represented them.
thank you.
Yeah.
Assuming from your experience that you understood a hypothetical.
Sorry, I'm gonna let Walter do this question because it needs some add. Okay, fine, sorry. Did we skip a question?
You did not.
Okay. We're good, sorry. This is Walter's.
Assuming from your experience that you understood a hypothetical issue that was trying to be resolved at a meeting, and you received a question from a board member that you believed was incidental or non-pertinent, how would you address that scenario?
I would try to figure out what they're asking, and I might ask them, sort of what exactly do you mean by that? But I would answer and maybe try to move the discussion to where I think it's going, unless I get sort of follow up by asking, what do you mean? And you did say it's at a meeting, right? So yeah, I would answer while at the same time trying to, try to figure out what it's about and trying to keep at least my involvement in the discussion or the discussion going in the direction that I think that it should go.
Thanks.
Well,
Yeah,
I don't
the follow-up
think it's-
was not
No, I don't think it's relevant, no.
Right.
Right. So that's the extent of our questions that we're asking of all attorneys. So now it's your turn to ask us questions.
I do notice that this position would be the fourth attorney in 2.5 years. Do you have any thoughts on why that's happened and whether or not, is there anything that I should know about the town attorney position in Peonia?
this town eats attorneys because it's a very contentious town. It is no longer as contentious in the meetings as it was. 2.5 years ago, it was practically a food fight. We had trouble getting through the meetings in 3 hours, and there was constant discord. Things have changed. I think that there's been a new election in April, and the board has changed again. But I think that we have a team that can work together to push the town's interests forward. And we don't have the contention we had at one time. I was here for 3 of the 4, and our last attorney got a job with Sursa. And I'm really unhappy that he left, but I'm glad for him. It's a really career builder for him, and he's going to do a good job there. Before that, the attorney simply was tired of the discord. He did not like the way the town was being run, and we did at times not follow his advice, and that was his main reason. And before that, I can't really put forth.
For the minority report. When they talk about discordant meetings, I feel like a lot of these questions were a result of my involvement as a member of the public, doing what I felt was my duty as a member of the public. And the board was very involved in protecting incompetent help staff and refused to take any kind of oversight or hold anyone accountable for many egregious acts. And from my perspective, when a board engages in that kind of behavior, they deserve anything they get. And when we talk about discordant behavior, your answer to the question about how do you deal with unruly meetings is like several other people who have actually experienced disruptive meetings. And what I perceive, especially with your guys' answers, is that this town has never seen anything like an actually disruptive meeting. There's been many comments that the board didn't like to hear and people that would argue with them. And they mistake this for disruptive meetings that would be going to the point of a legal action for disrupting a legal assembly or something like that. So that's the minority report.
And it's with members of the public. I guess one thing I'm getting curious about is how you all get along, or prior trustees, if the discord was among trustees, or it was
So it's
just.
between the public and the trustees. Trustees were monolithic.
Well,
No.
so if I might.
That's what it
step in,
looks like.
It's no longer monolithic.
Well, and as somebody who was in the public at a time, and really it boiled down to, we did not have good administration. And that created a lot of problems. And for the attorney at the time, because he got a lot of pushback with some of the product that was brought forward. So that person left. We had an interim administrator who came in and realized there were a lot of things that needed to be redone. That work got started, and then we hired our current administrator who has a lot of experience. And that has helped with the discord because we don't have the issues. You know, things are being done the way they should be done. And so our meetings are so much better because we're not having to try to answer for some bad management when the public's mad. So I would just say everything is so much better.
Yeah.
You know, I was a trustee and now I'm a mayor, and from my perspective, the best we can do is follow our code, be transparent, hear people's input, but we can only do what our code allows and what is fair for all the people that we represent, which was not necessarily the case with previous management. So that's my perspective on it. And we did lose an attorney that when I was a trustee, we hired. And I think he was quite disgruntled, but I'm not sure he was comfortable with the municipal law either. There were some times when I felt like he was giving us advice that I didn't think was correct based on our code. So that person said, "Oh, you guys, bye-bye." And then we hired Nick, who has, his whole background was municipal. But he came in when we also got our new administrator. It was kind of a perfect time of the people we needed here to help us move forward all showed up, you know, from the administrator and the attorney.
Another thing that's happened is we no longer micromanage town business. When I first started, we pretty much ran the town from the meeting, and that was a lot of the discord. This is a policy-making board, and I've been harping on this ever since I've been in this seat. And that's what we do. We make policy. We don't interfere with personnel. We don't give orders in town. And now it's starting to work. And with the administrator we have now, I am extraordinarily satisfied with the management of town. We're no longer managing town. We make policy. and that's great. And we hire lawyers, which seems to be a hobby for us.
Which is a statutory requirement.
Yes. Yes, it is. We
I'd
take it
rather not
seriously.
do it, but, you know, we need a good lawyer.
Do you think it's helpful to have someone here in person?
What was it?
Do you think it's helpful to have your lawyer here in person?
I have a personal opinion about that, and I think one of it was mentioned that you can kind of continue a relationship online, but it's hard to establish. So I think at least sometimes it helps for a lawyer to be here to get to know us and us to get to know them and our problems and issues.
I agree. I mean, I found that Zoom video is incredibly helpful when you can't be there, but you can't tell, how people are reacting. Can't really tell. what's
There's
going
an
on.
atmosphere you can't get from Zoom.
I would plan, during the winter it might be tough, but I would plan to be here as much as you wanted me to. It took me about an hour and 20 minutes today.
I can't remember how you were gonna build that in your resume, so I don't recall.
So I've got a
That
weird,
time.
yeah,
Okay.
I've got a weird billing structure too, which was like guess how much time you would use and said flat fee for that, and then higher fee for more. I've found people like the flat fee because of the certainty. If I guessed high on the hours, I would be willing to sort of put that flat fee portion lower or higher. So I would be willing to talk about that. And so the billing, and that's relevant to the billing of the driving, which is I say, I would bill it at half. And so I would say for, every hour, this would be a 2 hour and 40-minute round trip. I would bill an hour and 20 minutes for it.
Because it seemed to me you had 30 hours.
I guess
I didn't, I brought my computer, but not my plug, so I can't look. But I remember you were doing 30 hours, I think.
I guess
at
35.
6,000 something, and then travel would be included in that 35 hours. Is that right?
I would bill it as half,
Yeah.
half the time in that 35
As
hours.
part of that lump, the lump. Yeah, thank you. I just couldn't remember the
Being
details.
new to the board, I was just guessing at how much we would need an attorney. I hope we would need one less than we used to. So, and it's hard to judge, yeah.
Yeah,
how
Stefan gave
many
some hours for Nick in our last meeting. Now I can't remember them all. He went through the invoices. I think we were 15
Yeah.
hours. I don't remember, but it all depends on what the issues are, and some of that is really unpredictable. But we are in the process. We just hired a contractor to go through our code, do a lot of cleanup because we have a lot of inconsistencies and our land use codes, it's kind of a mess. So that, I think, when we get that finished, will help us a lot because some of our issues are inconsistencies in code. So then what do you do?
Right.
How do you deal with that? And
Especially when someone relies on it
Yeah.
for property decisions.
exactly. So hopefully we will be better off here in the next about 9 months. Other questions for us or anything else anybody else wants to add?
Well, I've enjoyed talking with you and certainly am interested. I'm glad to sort of hear about the past with the other attorneys, but it's a great town. It's close by. And to hear from you, I'd be interested in working for you.
We have one more interview today and then we'll be following, I'm not sure exactly what we're gonna choose. Because we would like to do follow up with checking references is our next step. So I can't give you a date yet, but we will definitely be in touch.
Sounds good to me.
And by one of our really excellent staff members, which we didn't add that, our staff is really good. The two in the room and the public works and we're really, it's a big improvement.
Glad to hear it. Thank you all.
Thank you. Safe
Careful
travels.
driving.
Correct.
Yes,
Dear.
whenever it's wet. Do we know if the other person is in the queue? Are we too early? It's not quite quarter of.
I actually have to let me go text it
Okay.
and see.
You want to pause the recording?
Next, right here. John Melanie.
John, take a shot.
Oh, that's.
We're unmuted in camera. Mayor.
Oh, do we? Oh, sorry. Hello. Hello, do you go by Joe or Joseph?
Joe, and that's what happens when cyberspace drops you right into the meeting, right? Like Star Trek, right? Sorry about that.
I should have been looking up. So, sorry, hi, Joe. Are we okay to call you
Oh,
Joe?
no, please do. Thank you.
Okay, well,
Okay.
I'll introduce myself. I'm Paige Smith and I'm the mayor. And I will just have all the other trustees introduce themselves to you and then we'll launch into some questions.
Okay, thank you.
Track the camera there.
You probably can't,
Hello?
Hi.
no camera.
No camera.
Here we go.
There we go.
Yeah.
Hi, Bill Brunner, trustee. Hi, Joe.
Hi. Pleasure to
Joe,
meet you.
Kathy Swartz, trustee.
There it is.
John Valentine,
Hi,
trustee.
how are you? Hi, how are you? Is that John, you said?
John Valentine, trustee, yep.
And Mayor Pro Tem.
Pleasure to meet you.
And I'm Walter Check, trustee.
Good afternoon, Walter.
And I'm Rick Stelter.
Hi, Rick.
You do.
So thank you for joining us, and I'll just open with the open-ended question of what makes you interested in working for the town of Paonia?
Okay. It's I have only, as an attorney, I only have served as my clients have all been municipalities or local governments. My first job, I was a deputy district attorney for the 17th Judicial District. That's Weld County, northwest of Denver. I was a DA for about 3 or 4 years thereabouts. I think closer to 3. And then my next job, I was a deputy city attorney for the city and county of Denver. In that capacity, I represented Denver in lawsuits regarding every aspect. Denver is self-insured, which means they don't use CIRSA, unlike almost every other city and town in Colorado. And they have a large litigation section that handles all of their litigation. So I handled everything from car crashes to nuisance complaints to zoning issues to fairly serious police crimes. And then my next job was with his firm, Murray Dahl, Beery and Renault. So it's part of my DNA as an attorney to work for the public good, working for local governments.
Thank you. Bill, I'll let you start.
Okay. So the first question is, please describe your experience addressing issues regarding water rights, water sewer infrastructure, and water availability for residential users on the western slope.
Okay. I have lots of experience with parts of those questions. So let me tell you what parts I have lots of experience with and those parts where my experience is more limited. And so I've done a lot of litigation and a lot of negotiations regarding IGAs, intergovernmental agreements regarding water rights, but I've also always done so accompanied by a water attorney. It's I think a better practice to have a water attorney on board. They can provide guidance as to the decrees, what water the municipality has, revising the decrees and the nuts and bolts of the water rights. That's by no pun intended, that's pretty deep water. And I think you need to have an expert for that. So we have to have a water attorney on board. But accompanying a water attorney, I've done lots of work regarding water. I've been involved in litigation regarding the building and maintenance of sewer infrastructure, condemnation, handling the building of a sewer plant. In so doing, I have learned a lot about how waste is processed and handled. I've also done some litigation regarding IGAs, regarding water availability on both the clean water side and the wastewater side, regarding the transportation, the transport, storage, and use of and payment of water and both clean water, potable water, as well as wastewater, and how that is funded by water taps, either sewer water taps or clean water taps. I have not done that for any client on the Western Slope, but I've done that for clients all along the Front Range.
And then let's see the follow-up.
Oh, actually, let me add to that. I forgot one piece. Also, I fancy myself an expert in property law, and so to the extent that you need property rights to serve as the site for the water conveyance structures, the pipes, the infrastructure, things like that, I've done a lot of work with that. And in my wearing my condemnation hat, I've done a lot of work in terms of not only widening roads, which happens quite often, but when roads are widened, what should happen is that the underlying infrastructure should be replaced. And I've worked with the service providers to do that, to make sure that if you're going to rip up the road, it's smart to replace the underlying infrastructure, both wet and dry utilities. Wet utilities is wastewater, dry water. Dry utilities is, internet, electricity, things like that, cable, things like that. So I've done a lot of work in that, and also in implementing services for the construction of that infrastructure, whether it be a water plant or water lines. I've worked with, on behalf of municipalities, negotiating contracts with the service provider, the guys who build the water tanks, the guys who build the lines.
Great. So, what did you do to get all of the information?
I asked a lot of questions, and you do a lot of reading. As a litigator and as a town attorney, they're very similar. You need to be responsible for all of the information, and that's the starting point, right? You need to know kind of how the pieces lie on the table, all the cards that are available to play for your client. If it's an adversarial kind of situation, you have to understand the cards that the other side might be holding, and it's your job to figure that out as the base, as the foundation, so that you can provide appropriate counsel to your client.
Okay, so please tell us about your most contentious negotiation and how it was resolved. In addition, please describe your experience with alternative dispute resolution. Okay.
I think those are one and the same. I've had lots of experience with alternative dispute resolution. I do a lot of work with, often cities and towns that are in conflict with one another, or with developers, or with service providers. And the ways to resolve that conflict, basically, there are only two: negotiation or court. And I find that a court is, although an avenue available to the town, is the less preferable of the options available, and it's always better to settle if you can. Settlement provides lots of opportunities, the most important of which is it helps you guide your destiny and make sure that you know what you control the outcome. If you go to court and you have a judge or a jury decide the outcome, well, then you've lost control. So it's always better to keep that in mind and engage in negotiations early and often, and as often as necessary, to try to come to a negotiated resolution, which is always superior. So I've always done that. I'm a big proponent of negotiated resolutions. Secondly, I've used alternative dispute resolutions in the form of mediators. They call them neutrals, and those are almost always retired judges. And those retired judges basically help mediate disputes between municipalities, or between municipalities and service providers. And I have found those to have work very well. Most often, particularly if you have done enough work before that to figure out exactly what issues are resolvable, which ones are not, and have a good strategy in place to guide the negotiation to a place that is mutually satisfactory, or the best solutions are the ones that both sides hate, right? Or both sides kind of hold their nose at. And particularly in a litigation context. The most recent one I've worked on is for the town of Mount Crested Butte. They had a affordable housing development where the developer went belly up, and the property rights were owned by the developer. And I worked with the town and the developer to basically negotiate the resolution of that, where the town was able to regain the property rights in a way that was acceptable to both the town and the developer. And now the town is busy building affordable units on that site.
Okay.
And for that, we use the ADR. I'm sorry. For that, we use the ADR, which is the guided mediation by a judge who serves as a neutral mediator.
Fantastic. And could you tell me what's been your experience with prosecuting ordinance violations in municipal court?
Okay. So for this particular engagement, we are offering the services of Nick Klein to be the prosecutor for criminal court, and he serves as the municipal prosecutor for criminal court for 3 or 4 municipalities already. But I also have extensive experience doing that. When I first came on board with Murray Dahl, I was the municipal prosecutor for Edgewater, and a little bit of Wheat Ridge. And I only mentioned that because it's a little bit different than being a prosecutor for the state. As I mentioned, my first job out of law school was a prosecutor for the state, and there are some differences, some important key differences between those two. But I come to the table with those experiences. And then in addition to municipal prosecutions for criminal offenses, which will be primarily handled by Nick, we also, our firm and myself and Nick also have extensive experience prosecuting code violations, which I think are more complex, more burdensome, have stronger personalities. These are the folks who I'll use one example, who maybe added a few bedrooms to their home without pulling the proper permit, and maybe are using those bedrooms for short-term rental, and maybe like the money that's coming in and don't want to get rid of it, but it's against code. Hypothetical example, of course.
Thank you.
Could you explain your experience with developing wording describing the purpose of an executive session for incorporation into a trustee meeting agenda with respect to Colorado open meetings law?
Okay.
What's your approach when advising trustees on the pros and cons of entering into an executive session, which is not part of the agenda?
Okay. I think one of the skills that I could bring to bear on behalf of the town of Paonia is understanding how a case or an issue or a question or a conflict kind of moves through the processing phase, whether it's through litigation with the judge, or whether it's a zoning issue with the local government, or whatever, what have you. Watching, understanding the nature of the conflict, understanding the decision points that are available to the council, preparing them, understanding whether it'll be a contentious issue or not, and preparing the council for that, in particular the board chair. And in doing, what I do is I make scripts, quite literally scripts. I call them executive session scripts, and I try to put under elbow of the board chair scripts that that'll be motions that are anticipated, decision points and motions, and then also under that, to answer your question specifically, executive session and the motions for that, the magic script that talks about how to go into executive session, that announces it to the public, the one that at the beginning, the script at the beginning of the executive session, where only the board is present, and then the script at the end of the session that takes us out, and be mindful of placing that executive session, if it's the custom of the municipality, at the end of the session, so that that when the board goes into executive session, if a decision is not required, then we can adjourn the executive session, which in turn adjourns the meeting. As far as when to go in and under what bases. The bases are laid out in statute 266402, and I'm well acquainted and applied those dozens of times, and so I understand which exception to use. The harder call is understanding the nuances of the situation at hand, and working with the board to determine the pros and cons of whether a matter should go into executive session, whether it needs to go into executive session, or whether it's the board's call. It's always the board's call to go into executive session or not, but sometimes there is some transparency issues that maybe a board would like to have it in open session, and sometimes executive session is required to preserve strategies and negotiation techniques and things like that. But all of those are decisions that I would hope to make with the board chair and the board, and work through those decisions at the board's discretion. With that, with Open Records Act, that's a tool, and that's a tool that should be guided by the principles and policies of the board.
That was you, Ms. Meehan, huh? A sense of urgency can at times compromise thoughtful decision-making and a thorough process. Can you think of a few examples of when this happened and what was your role?
Oh, yeah, rushing. When you rush, you make mistakes. I agree with the premise of the question wholeheartedly. I try not to rush. Quite honestly, what I would try to do if I'm not sure of the advice I'm asked to give, I will hit timeout. I'll say, stop, I don't know the answer, or I think it may be X, Y, or Z, but I'm not sure. And this seems like an important question. What I would do and have done is basically offered a tentative opinion, and then asked for more time to provide a memo on the issue that I endeavor to send out the next day or very shortly thereafter, that provides the decision, my guidance. But I would want to avoid a situation where we're rushed and have to make a decision. And I think it's better to if you can, if there's any opportunity, just kind of stop the presses and ask for more time and admit that you need more time, because some things cannot be undone. And it may be a little bit uncomfortable to ask for more time, but I have yet to, but the discomfort of making the wrong decision probably outweighs the discomfort of asking for more time, in my experience.
And a second part to this, tell us about a time when you came across a situation or decision that you didn't agree with. How did you handle that?
Okay, well, that happens all the time, and it's a nature of the job, and it's first off, it's not my place to disagree or agree. So you're the board of trustees. It's your job to make the decisions for the town. My job is to help facilitate your decisions, and so whether I agree or disagree on a personal level is of no import. What I do for you is advise you of your options. Our Jerry Dahl is one of the partners at our firm, and he's trained me to provide and this is a kind of a joke for our clients, the 3 doors, and you'll have 3 doors, 3 options, A, B, or C, and those are the options available to you. And those are the options that you should pick, and I can provide guidance as to whether those are what are the pros and cons of each of those options. But ultimately, you decide. A lawyer should not be involved in policy making. A lawyer should only facilitate your decisions, and then when you make those decisions, help make sure that those decisions have been supported by procedure and thought and research, so that they're defendable and easily defendable.
Thank you.
What is your experience with disruptive or contentious meetings, rules of procedure for board meetings or other meeting situations that require attorney involved to help maintain order?
Yeah, local government is sometimes messy, and sometimes folks come to the table heated about a whole number of issues. And I've been in meetings with public comment that lasted hours, and I'm sure you've been in those meetings as well. And so what you do there is I've been able to work with the board chair and the board to basically make those meetings as orderly as possible. And so that's an example where we'd have a script where I would ask for a meeting with the mayor or the board chair prior to the meeting, and we walk through strategies of how to handle the information, how to handle all the folks who want to speak, and how to do that. And one of the easiest way to do it is basically be consistent in how you handle your open meetings, your public comment. So if for example you have a hearing and it's your town's practice to have 3 minutes of per speaker, then on the less contentious issues, 3 minutes. On the more contentious issue, 3 minutes. Establish a practice, policy, and custom of being consistent about how much folks are expected to talk. If you have a lot of folks talking, there are lots of things you can do to facilitate making sure everybody's voice is heard. For example, if you're way into the night, you can ask for folks to combine their time or work together to have similar issues to work together. But mostly it's consistency, making sure everybody's heard, making sure that the rules of 3 minutes are kept, making sure everybody remains respectful, and making sure everybody has, as we've accommodated their right to speak to the extent possible.
That sort of relates to my follow-up here, and that is, what advice could you give us about inclusion of public input as it relates to the length of meetings and making wise decisions.
Yeah, I think the best thing is to try to manage expectations as much as possible in the front end. I've been involved in, and like I said, meetings that had literally, I'm trying to say if hundreds is the right word. Yes, I think hundreds. I've been involved in a meeting with literally hundreds of people about various issues, mostly having to do with development. Those are the types of issues that bring everybody out. And so what you do there is you basically make sure that you work with folks to make sure that everybody gets the chance to be heard, make sure the developer gets the chance to be heard, make sure that the primary opponent, to the extent it's a hearing, might get a chance to be heard. Make sure that you, one of the things that I have found incredibly helpful is to have kind of almost an agenda, a mini agenda within the hearing. So for example, if it's a zoning hearing, you have posted or easily displayed kind of where we are in the proceedings. So if it's a rezoning or a zoning issue, the developer speaks first, and then the public speaks, and then there is board comment, and then there's developer gets the board gets to ask the developer questions, and then the public gets to ask the developer questions, and then the board gets to ask the public and the developer questions, and then there's board only comment. And so and have kind of a quite literally a kind of where we are, follow the bouncing ball, where we are on the agenda on the wall, so that everybody knows exactly where we are. Because I think at that point in the most contentious meetings, it's important to gather everybody's input at the same time, make sure that we're only gathering that input that is relevant and appropriate. So when we get to the point of board only discussion, everybody understands that their time to speak is over. Now it's board only discussion, and we need to make a record to support that board's decision.
Can you describe an example of a time when your legal opinion helped bring forth a positive outcome to the community?
Yeah, I think that the example of which I rely on the most lately is the Crested Butte example. I think that affordable housing is a huge issue in the mountains at this time, and a huge issue, frankly, everywhere. I live in Denver, and affordable housing is top of mind, top level issue for, I believe, as far as I understand, every local government throughout Colorado. And I think that's an issue that needs to be worked through, that needs to be aggressively addressed. And I like to help with those types of issues because having people who live in your community brings the sense of community. But also one of the things that I like most about being a local government attorney is that it's local government, and much like you, these are folks who they're not their day job. This is their job after hours, and these are people who are willing to contribute to the health of their community. And not only you as the board members, but also all those folks who show up at the junior high school gymnasium on Tuesday night, on the third Tuesday night, and everybody is there for ultimately the same reason, which is to make their community better. And I think that is and to my extent that my job is to help these folks, you and other communities do something that they feel is the right thing for their community is a nice it's a nice feeling to have, and it's a nice job to have.
Now think of a time when your opinion was not well received. What was the result?
I guess there's an analogy that if I'm selected, I will give to you quite often. So I'll just trot it out now. So as a lawyer, my job is ultimately to provide a service. And that service is to help you make a decision. And those decisions are under doors A, B, or C, or 1, 2, or 3. Also my job is to make sure that you don't make decisions that are illegal. And so by using the way of an example, a service provider, a cab driver. So you can tell me you want to go to A, and I can say the best route is over the bridge and through the woods, and I could select that, and then you can ask me to do things that maybe then we could talk about going fast or whatever, not above the speed limit, which we wouldn't do. But let's say if the road is icy and you want to go faster, and the road is a little bit icy, and then I would talk to you about the pros and cons of traveling fast. And ultimately, I would give you the pros and cons of traveling fast, and then have you make that decision. To the extent that that there is some question about some decisions are ultimately very much at issue or in conflict still, even though there was a majority vote for one way or the other. And in those instances, sometimes a memo, a follow-up memo whereby the decision is explained, the pros and the cons are explained, the reasoning for the decision, and also the support for kind of anticipating bad future actions. Those kind of things are follow-up that are sometimes necessary to make sure that everybody understands what we did and why we did it. As far as but I feel like I missed your question a little bit, so please repeat it. I feel like I went off on a little bit of a tangent there.
Okay, now think of a time when your opinion was not well received and what was the result?
Right, fair enough. I don't. Sometimes lawyers bring bad news, I think, is also an issue. And what you do there is you try to be as objective about it as possible. You put the analogy I use is you put the piece of the bad news, you try to hold it in your hand, you try to hold it up to the light, you try to put it on the table, you look at it and you try to explain it. And then you try to help everybody understand what the bad news is, why it's bad news to the extent that's necessary for a discussion, and then explain the options. But sometimes, often, my job as an attorney is to bring bad news, and the best I can do in those situations is to try to provide a solution to that bad news, and provide a proposed pathway as soon as possible for a way around or out of that bad situation.
Well, you're number 7.
Right. So please think of a time when you had to redo a work product because it wasn't up to standards. What was the context and the outcome?
I thought about this question a lot in preparing for this. I don't think that I've been in a situation where the quality or my work was at issue. I have been in many situations where folks didn't like their options, or maybe didn't understand their options, or it was an uncomfortable situation. And I've had many situations like that. And my hope is to continue to have that quality of work, to kind of talk about rushing. And I see that the next question is I don't like to rush. But sometimes you're required to rush, and I understand it's my job sometimes to burn the midnight oil to get an opinion out, and I'll do my best to get that opinion out as soon as possible. And my family understands that as well. But I think that our firm has been doing this work so long, and there are so many of us who do this work so long, that we have at my disposal on speed dial somebody who has had a similar problem, a similar issue, and we can recreate. I can find the files for that issue, and we can analogize from that and figure out kind of what the law was and what the options are. We as a firm just don't come across very often, and very rarely do we come across anything that is a new problem. Most of the problems that are presented to us are problems that we've had experience dealing with in other capacities and at other cities and towns. And maybe it's not the exact problem, but at the heart of it's the same. And so there are no things that come at us that are just unprecedented. And so that helps quite a bit to make sure that we're available and we're ready to help you figure out what the problem is, what the solutions are, and how to get those implemented.
So the follow-up is, what methods do you use to check for quality, especially when you have to meet tight deadlines?
Okay. Well, if it's an easy one, right? So if write and write often. So if you want a memo, and I need to get you, it's a Monday night, I need you to get and I was assigned a memo on Monday night because something, some kind of unfortunate emergency happened, and I need to get you a memo by Wednesday. what I do is start writing right away, and then make sure that mostly that you're not seeing a first draft or a second draft, you're seeing like a fifth draft. And also call upon my colleagues to help me understand and work through this and see anything that I don't see. But the cumulative strength of our firm is that, as I mentioned, is that all of us have worked in this realm for quite a long time, and there's just very few issues that we haven't encountered before. So we have somewhere in our tool bag a tool for that, and have fashioned a tool for a particular issue. It's just a matter of finding the file, looking at the law, and figuring out what it is. And then what my job is, and this is, I think, what is the most important, one of the most important parts of my job, and it's something I learned early on as a district attorney, is that the most important part for me is to make sure that you understand what I'm saying and make it these complex issues, if they are in fact complex, make them easily digestible, easily understood, easily relatable, so that you understand what your options are. And that's something that's a skill I've honed by being a litigator, by explaining to juries very complex situations. And if you can't make it simple, then you don't understand it. That's pretty much how it works, and we have encountered all of this stuff, so we understand it, so we can make it simple. And so I think sometimes when there is unhappiness or with the communications, it's often the fault of the attorney for not making things as digestible, as easy to comprehend, as simple as they could be.
Hey, thank you, Joe. Okay, could you please describe how many municipalities you're personally representing at this time? And will you have any scheduling conflicts that would require others to serve in your place?
Okay, I am at present not a city attorney for any municipality, so I don't have any scheduling conflicts. I do a lot of work for all of our clients, all of our municipalities for our clients. I do a tremendous amount of work for two in particular, the city of Wheat Ridge and the town of Georgetown. I do a lot of work for those two, but I do a lot of work for a number of all of our. I do work for all of our clients, and so like I said, we have those issues before us, and I've worked on them, but I'm not a city attorney at present for any city, so I'm free on Tuesday evenings, and we have also checked our records and do not have any conflicts, not only scheduling conflicts, but legal conflicts with the town of Peonia.
Excellent. And then maybe you can just speak with, Wheat Ridge and Georgetown and the other towns that you represent, or not represent, but you work with. How many of them are statutory towns?
There was I worked for the town of Monument. So the town of Monument is presently a home rule town, but when I worked for them, they were a statutory town, and I worked for them for about 3 years. So I have lots of experience with a statutory town, and in fact, statutory towns are fairly straightforward because it's a statutory town. So if the statute says you can't do it, well, you can't do it.
Thank you.
Right, your turn, Walter. Coming from your experience that you understood the hypothetical issue the board was trying to resolve at one of its meetings, and you received a question from a board member that you believed was incidental, not relevant to the issue being addressed. How would you deal with that scenario?
Okay, that's a little bit different than the question as on the handout. You said it was not relevant. So I thought I heard that.
Well, yeah, that's why I read it out and changed it a little because it was confusing the way it was written.
Okay.
Instead of incidental, what I really meant was it wasn't relevant to the issue being trying to be resolved.
Okay. I researched the town a little bit as part of the RFP process, and one of the documents that I came across was a document that talked about a process for securing attorney opinions. And that is very helpful. And I was happy to see such a document because what that does is that manages costs very effectively. It allows the town administrator, town manager to control kind of my costs and my access and make sure that my time and my expense is not being run up by an irrelevant question. So that's helpful. And so I think my sense is that process would solve much of those issues that arise from that. To the extent that it doesn't, to the extent that there are ongoing questions that are perhaps relevant, and that happens quite often. So there is the hearing type environment, and if I get a question from someone about a hearing issue, I'll be very clear with that person that the rules of quasi judicial process means that the board has to hear all of the information at the same time. I'm sure that your present counsel will talk to you a little bit about that. So I'll make sure that we're not having ex parte communication or quasi judicial communication about the matter at hand. To the extent that that's not the issue, or it is, I'll explain that's the issue and say we can't talk about it, make a note of it, and bring it up at an appropriate time when the board is deliberating that topic. The other issue is that, and this is certainly something I've encountered, where there's been a question or an issue that has been extended across several board meetings, and I get an email message from trustee X who has a question about Y project, and that happens quite often, even where do you have or is approved by the town administrator for me to answer. And so that is easy enough. What you do then is you basically research the question, answer it, put it in a memo, and then hit reply all and form it as a attorney-client confirmation for the entire board and state, I received this question about X project from Y trustee. Here is my answer to her. And everybody gets it.
Yeah, sorry, I didn't write that question as clearly as I could have.
Does that answer your question, sir?
Yes.
Okay.
So that's all the questions that we had organized for you. So what questions would you like to ask us?
I learned about, I read this article, I was doing a little bit of research about you, and I read this article in the High Country Shopper. I'm not sure if that's the name of it or how it shows up over on just on the internet, and it's about the water issues. And it sounds like you have had some serious infrastructure issues. You were able to obtain some loans either from the Department of Local Affairs or Colorado Department of Public Health and Environment, or both, to obtain the funding necessary to address those. And now you're in a kind of funding that through loans and bonds. But I have some questions about it also appears that you hired a city water attorney and also some other folks. Where are you? What was not sure is kind of where are you in terms of resolving those issues?
Let me just answer one part of it. We have not hired a water attorney yet.
Oh, okay. Okay. I must have misread the article.
Well, we're getting our code rewritten. We have a contract working on rewriting our code. And as part of that, there is a water attorney helping on pieces of the code. But we have not formally hired a water attorney yet.
Okay. Got it.
Bill, you want to
Yeah, so we have a water moratorium.
Yes.
Right now, because we've got kind of a unique situation. I think we've got a huge water system that's really far flung and very poorly taken care of. It's left us way behind the 8 ball. In addition to that, there's issues with the ability to store water so that when the springs don't flow so good, we can still supply, coupled with a lot of outstanding taps. And frankly, and honestly, I'm probably the minority report on this board, but the water moratorium is 4 years old, and the previous board did very little to address it. And so there's been significant work in catching up with the deferred maintenance on the system, but we've got a long ways to go on actually straightening out our underlying problems with water, which is basically lack of storage or some very creative solutions that we haven't really discussed yet.
Okay. It sounds like, at least from the article that I read and a little bit of research I read it, it appears that the funding has been secured. It's just a matter of entering into the contracts with the service providers to build the infrastructure. Is that a fair characterization?
No.
It's a little too optimistic, what you've just said. We have not gotten, we're looking to get a little bit over $8 million of a low interest loan from the revolving water fund to replace 8,000 feet of our delivery pipe.
Okay.
But there's numerous issues with that pipe because a lot of it runs through private property. We don't want it to be in private property any longer. We want to get right away. So we have a lot of land issues associated with that. And we did get $1 million. We have to reline our 2 million gallon tank. The lining, the food grade lining is sloughing off, and it has lead-based paint in it. So that all has to be taken out, and we're going to have to find some more grants or loans to finish that. And we are not looking at any bonds at this point. We are looking at grants and low interest loans with loan forgiveness, hopefully.
Okay.
But we have kind of a summary value that if we have to do a new sewer plant in order to achieve the cleanup levels we need to, we may have to resort to a mechanical plant, which would mean one of the estimates of our outgoing mayor was $50 million for that sewer plant because it is 8 miles from the town. And we have to replace all of the clay pipe that is behind many of the alleys in the old part of town.
Okay.
So we not only have the collection system needs to be replaced. Luckily, I think our pipe between town and the sewer plant is in good shape. I think we're good on that, knock on wood. But we have a lot of open-ended continuing upgrades and potentially replacements to be done. So we are heavy into our capital improvement plan. We have hired 2 different consulting firms. We have a hydrologic engineering firm helping us with getting all of the engineering plans in place for the 2 million gallon tank being relined. We have to buy some property next to it and put a temporary tank in to fill, to take it to all of our users. And we have an engineering firm that's also helping us with this, as well as we have numerous streets that need to be fixed. So it's we have a big can and the lid is opening and about to suck us into it. The one that's been kicked down the road for so long. We have a lot to do.
Understood. Well, I have one other question. What are you looking for in an attorney?
See, a sense of humor is helpful.
Always. Sometimes you can only laugh.
Yeah, anyway, because we like to laugh. Yeah, go ahead.
Yeah, so for me, it's like, I want an attorney who's not afraid to call us out if we're steering off track, if we're not following best practices, if we're not being transparent. I want an attorney who's just be like, hey, you all, stop. And to call us on that, because we want to do right. But sometimes you just need that outside opinion who's not emotionally invested in whatever we're talking about. So that's what I'm looking for, is like, just call us on our stuff.
Mm-hmm. And I can do that, but mostly when I talk about the doors, so those doors are policy decisions, and those are decisions that are for you, and I shouldn't be involved with that. However, the procedures to get to those policy decisions are something that I should be very much involved with, and it's my job to make sure that you stay within the lane. So, for example, the easiest example is when it's that portion of the hearing where it's board only deliberation. Make sure that no one else in the gallery talks. Simple things like that, but those are important procedural safeguards.
And if I could add, something that has come up occasionally is, you just said a very interesting thing, that a statutory town, if the statute says you can't do something, you can't, that's your guidance. Well, we've been told at times that we don't really have to follow the statute, and we've been told at times that, you don't really have to follow that code. And it's very problematic to hear that, because I took an oath of office to follow our code. So I guess I would not want to be given, distracted with, well, no, you don't really have to follow that, even though that's what it says. So if you were to say that to us, I would want to clearly know why are we being given an alternative decision point? So that's from my perspective.
Okay, so exactly. So the statutory town, the rule is basically you have all of the enumerated powers and all of those powers incidental to those powers, all those powers necessary to implement your decisions. So it's very much a policy conceptualization, and so that's what you can do. I'm not obviously not familiar enough with the ins and outs of what happened in the past, but to the extent that you can draw pretty much a straight line to a particular enumerated a power in the state code, or an implied power that says this is the authority necessary to implement that particular act. That's something you can do, and that's a policy decision. What's important, or that's the power. How that's different than a policy decision is that there are could be 3 or 4 or 5 options that are within that realm of authority. So you have the authority to build roads, but it's your decision which roads to build, where they should go, what type of roads they should be. Does that answer your question, or am I getting at what you're?
But I mean, there was a time when we were told that we could ignore that code and make a decision that we had no authority to make. That's what I mean.
Okay, I'm not familiar with that, and everything is the law is complicated, and I'm not going to comment on any kind of thing in the past. But my training is that if it's a statutory town, you should be able to draw a pretty direct line from the statute to what you're doing.
Okay, thanks. And Rick, you had your hand up.
I think I can clarify that a little bit. We recently appointed a town treasurer, and the advice was that we did not need to necessarily do it because there was no penalty clause in not appointing a town treasurer, and that it was a semi-ceremonial position. It's not, it has no statutory duties. It was left over from the days when you just had the town running the whole everything, and you needed a treasurer in those days. Now we have finance officers and we have finance committees, and it's not well, our attorney apparently thought that we could go ahead and not appoint a finance officer treasurer. And that was the advice we were given. And as there was no penalty, we went ahead and decided to appoint a treasurer after all. But it did take up quite a little time, and some legal time too.
So, anybody else want to answer that question, or do you have any other questions for us, Joe?
I think,
Okay.
I think an attorney that's not afraid to deliver bad news is invaluable. Myself, thank you.
No problem. Yes, it's part of the job.
Yeah.
Anything else for us?
I don't have anything else. If you don't have any other questions, thank you for your time, and thank you for the opportunity to visit you via Zoom. If selected, I would be welcome the opportunity to figure out a schedule to visit you on a kind of a quarterly basis or something like that. But those are discussions for perhaps another time.
Yeah, that sounds great. And we will be following up with references and then be making a decision. I don't know quite when, but we'll let you know. Yeah.
Thank you so much. Have a good evening, and thank you for your time.
Thank you very much.
Thank you. Bye.
So now I need, and I would
For a 2 sub 4 sub E, as per the town attorney contract.
okay, do we have a second?
I'll second that.
All in favor?
Aye.
Okay, so we will, I think we're gonna go into Stefan's office, right? Which is what we have to do. Okay. The time is now 7:04 PM and the executive session has been concluded. The participants in the executive session were Administrator Wynn, Trustee Stelter, Trustee Check, Trustee Valentine, Trustee Schwartz, and Trustee Groom. For the record, if any person who participated in the executive session believes that any substantial discussion of any matters not included in the motion to go into executive session occurred during the executive session, or that improper action occurred during the executive session in violation of the open meetings law, I would ask that you state your concerns for the record.
And Mayor, you forgot to include yourself in the.
Oh,
in the
I
meeting.
did it in the last time too.
Yeah.
Okay, sorry. Do I have to read it over? Okay. Okay. I would ask that you state your concerns for the record, other than that. Hearing none, the next, hearing none. Would someone like to make a motion?
I'd like to make a motion to instruct Administrator Wynn to follow up with the references of our attorneys, the attorneys candidates, and to give a report to the board.
Second?
Second.
Let me just make sure. Did you get that? Okay, all in favor?
Aye.
All right. Thank you. We are adjourned.
All tomorrow.